What procedures are covered by the rule on cybercrime warrants? The rule on cybercrime warrants covers the procedure for the application and grant of warrants and related orders involving the preservation, disclosure, interception, search, seizure, and/or examination as well as the custody and destruction of computer data as provided under the Cybercrime Prevention Act of 2012. What are the different types of cybercrime warrants? There are four kinds of cybercrime warrants, to wit, warrant to disclose computer data, warrant to intercept computer data, warrant to search, seize, and examine computer data, and a warrant to examine computer data. Let's talk about them one by one. First, a warrant to disclose computer data is an order in writing issued in the name of the people of the Philippines, signed by a judge, upon application of law enforcement authorities authorizing the latter to issue an order to disclose and accordingly require any person or service provider to disclose or submit subscribers' information, traffic data, or relevant data in his or its possession or control. Second, a warrant to intercept computer data is an order in writing issued in the name of the people of the Philippines, signed by a judge upon application of law enforcement authorities authorizing the latter to carry out any or all of the following activities: listening to, recording, monitoring, or surveillance of the content of communications, including procuring of the content of computer data either directly through access and use of a computer system or indirectly through the use of electronic eavesdropping or tapping devices at the same time that the communication is occurring. Third, a warrant to search, seize, and examine computer data is an order in writing issued in the name of the people of the Philippines, signed by a judge upon application of law enforcement authorities authorizing the latter to search the particular place for items to be seized and or examined. Lastly, a warrant to examine computer data is required to be applied for and obtained by law enforcement authorities upon acquiring possession of a computer device or computer system via a lawful warrantless arrest or by any other lawful method, and before searching the said computer device or computer system for the purpose of obtaining for forensic examination the computer data contained therein. What should be the procedure prior to the issuance of a cybercrime warrant? The judge must personally examine in the form of searching questions and answers in writing and under oath the applicant and the witnesses he may produce on facts personally known to them and attach to the record their sworn statements together with the judicial affidavits submitted. Where should an application for a cybercrime warrant be filed? The application for a cybercrime warrant shall be filed as follows. First, for violations of Section 4, cybercrime offenses, and or Section 5, other offenses of the Cybercrime Prevention Act, the cybercrime warrant shall be filed before any of the designated cybercrime courts of the province or the city where the offense or any of its elements has been committed, is being committed, or is about to be committed, where any part of the computer system used is situated, or where any of the damage caused to a natural or juridical person took place. Take note, the cybercrime courts in Quezon City, the City of Manila, Makati City, Pasig City, Cebu City, Iloilo City, Davao City, and Cagayan de Oro City shall have this special authority to act on applications and issue warrants which shall be enforceable nationwide and outside the Philippines. Second, for violations of Section 6, all other crimes defined and penalized by the revised penal code and other special laws committed by, through, and with the use of information and communications technologies, the application for the cybercrime warrant shall be filed with the regular or other specialized regional trial courts, as the case may be, within its territorial jurisdiction in the places above described. What is the period of effectivity of a cybercrime warrant? Any warrant issued under the rule on cybercrime warrants shall only be effective for the length of time as determined by the court, which shall not exceed a period of 10 days from its issuance. The court issuing the warrant may, upon motion, extend its effectivity based only on justifiable reasons for a period not exceeding 10 days from the expiration of the original period. Take note, a search warrant shall be valid for 10 days from its date. Thereafter, it shall be void. May cybercrime warrants be served extraterritorially? The answer is yes. Cybercrime warrants may be served extraterritorially for persons or service providers situated outside of the Philippines. Service of warrants and or other court processes shall be coursed through the Department of Justice, Office of Cybercrime, in line with all the relevant international instruments and or agreements on the matter. Will the rules of court apply in cases covered by the rule on cybercrime warrants? The answer is yes. The rules of court apply in cases covered by the rule on cybercrime warrants. The rule on cybercrime warrants supplements the existing rules of criminal procedure, which provisions shall continue to govern the preliminary investigation and all stages of prosecution of criminal actions involving violations of the Cybercrime Prevention Act, including all crimes defined and penalized by the revised penal code as amended and special laws committed by, through, and with the use of information and communications technologies.